Maybe you saw it coming. Either way, you're out. And right now, your employer is counting on one thing, that you don't know where the line is. Because getting fired is legal. But how they fire you and what they do while they're doing it is not always legal. And the difference between knowing that and not knowing it could be worth thousands of dollars, a reference letter, or your next job. This is what they cannot do. First, let's clear up the biggest misconception. In the United States, most employees are what's called at will. That means your employer can fire you for almost any reason or no reason at all. No warning required. No performance improvement plan. No explanation. Most people hear at will and think that means their employer has unlimited power. They don't. At will employment has hard limits, and those limits are where your rights begin. The same principle applies in the UK, Canada, and Australia, even though those countries have stronger baseline protections. In every one of those jurisdictions, how a termination happens matters as much as whether it happens. Here are 5 things your employer cannot legally do, even when firing you for a completely legitimate reason. 1. Fire you for a protected reason. Across the US, UK, Canada, and Australia, it is illegal to terminate someone because of their race, gender, religion, national origin, age, disability, or pregnancy. This is true even in at-will states. If you were fired shortly after announcing a pregnancy, requesting a religious accommodation, or filing a discrimination complaint, that timing matters. Courts look at it, juries look at it. 2. Fire you in retaliation. If you reported unsafe working conditions, filed a workers' comp claim, reported wage theft, or blew the whistle on illegal activity, and then got fired, that is retaliation. It is illegal in virtually every jurisdiction we cover, and retaliation claims are some of the easiest to document because the timeline does the work for you. 3. Withhold your final paycheck. In most U.S. states, your employer is legally required to pay you everything you're owed, including accrued vacation time in many states, on your last day or within a short window after. Holding your final paycheck hostage, even if they claim you owe them something, is illegal in most jurisdictions. They have other legal remedies. That is not one of them. 4. Defame you to future employers. They can say you no longer work there. In many jurisdictions, that's where their legal safe harbor ends. If a former employer lies about why you were fired, claiming you stole, that you were violent, that you were fired for cause when you weren't, that is defamation. It's actionable, and it happens more than most people realize. 5. Deny you unemployment benefits you're entitled to. Your former employer can contest your unemployment claim, but they cannot fabricate a reason for your termination to make you ineligible. If they fire you and then tell the unemployment office it was for cause when it wasn't, that is fraud, and it gives you grounds to appeal and potentially pursue additional claims. If you were just fired, or if you think it's coming, here's exactly what to do. Step 1. Document everything before you lose access. The moment you're terminated, your email access, Slack, and internal systems will likely be cut off. Before that happens, or immediately after if it already has, write down every conversation, every warning, every performance review, every message that's relevant. Dates, times, who said what. This becomes your evidence log. Step 2. Request your personnel file. In most U.S. states, employees have a legal right to request and review their own personnel file within a specific time frame after termination. Do it in writing. What's in that file and what's not in it tells a story. Step 3. Don't sign anything under pressure. Many employers will present a severance agreement at the moment of termination and ask you to sign immediately. Do not do this. You almost always have at least 21 days to review a severance agreement under U.S. federal law, and often longer if you're over 40. That document likely contains a release of all legal claims against your employer. You need to read it. Ideally, have an employment attorney look at it first. Step 4. File for unemployment immediately. Don't wait. File the same week. If your employer contests it, you'll have the opportunity to respond. and a documented, legitimate reason for your termination works in your favor. Here's the thing about employment law that most people don't realize until it's too late. The law assumes you don't know your rights. HR departments are trained to move fast at the moment of termination. Box on the desk, escort to the door, paperwork in hand, precisely because a confused, emotional employee is less likely to push back. Knowing these 5 things doesn't mean you're looking for a fight. It means you walk out of that room with your eyes open. A quick note for viewers outside the US. The UK, Canada, and Australia all have stronger baseline termination protections than US at-will states, meaning the bar for a legitimate dismissal is actually higher in those countries, not lower. If you're watching from those jurisdictions, the core principles here apply. Check your local employment authority for the specifics. If this helped you, or someone you know just went through this, share it. And if you want to know what else employers can and can't do, the Fine Print series covers a new situation every week. Subscribe so you don't miss it.